Hello and welcome. My name is Alan, and today we will be doing 5 more justices of the Supreme Court. These are Levi Woodbury, Robert Cooper Greer, Benjamin Robbins Curtis, John Archibald Campbell, and Nathan Clifford. 5 more members of the Taney Court. So let's go ahead and jump right into this. The first one we are going to talk about today is Levi Woodbury of New Hampshire. He was picked out of New Hampshire, and he replaced Joseph Story. He was chosen to be a Supreme Court justice by James K. Polk. Woodbury would serve for 5 years and 346 days from September the 23rd, 1845 to September the 4th, 1851, dying while still a Supreme Court justice. Delving into Woodbury a little deeper, we see that he was born December the 22nd, 1789, in Francistown, New Hampshire, and died September the 4th, 1851, in Portsmouth, New Hampshire. And as a Supreme Court justice, he also handled the First Circuit Court. The education that FJC.gov has is that he went to Litchfield Tapping Reeve Law School, Dartmouth College in 1809. He read law in 1812, and before becoming a Supreme Court justice, he was a private practice lawyer in Francistown, New Hampshire, from 1812 to 1816, a clerk of the New Hampshire State Senate from 1816 to 1817, an associate justice of the New Hampshire Superior Court of Judicature, 1817 to 1823, governor of New Hampshire, 1823 to 1824, a private practice lawyer in Portsmouth, New Hampshire, in 1824, a speaker of the New Hampshire House of Representatives in 1825, a United States Senator from New Hampshire in 1825 to 1831. He was state senator-elect, but did not serve for New Hampshire. In 1831, became Secretary of the Navy, 1831 to 1834, was Secretary of the Treasury from 1834 to 1841, was once again a United States Senator from New Hampshire, 1841 to 1845, before finally being nominated to be U.S. Supreme Court Justice. Let's take a little deeper look at Levi Woodbury here. First, we will look at Britannica.com. During the Panic of 1837, Woodbury was able to maintain the credit of the federal government and benefited many state banks by doing so. He headed the Treasury until he left cabinet in 1841 and was reelected to the Senate. 1845, appointed by President James K. Polk and confirmed January of 1846, served on the court until his death, and was always considered rather conservative for a New Englander, And on the court, he took a strictly constructionist view of the Constitution. He was known for his dissenting opinions and was frequently upheld the state's rights over those of the federal government. He was born to a wealthy family. Though Woodbury had tried studying law at a law school, he quickly decided that he did not enjoy this practice and opted for the old-fashioned apprenticeship method instead, and trained under Samuel Donna first, then left Samuel Donna to study under Jeremiah Smith of New Hampshire. Woodbury chose to align himself with a political party known for its association with President James Madison and the Jeffersonian Republicans. This was a relatively newer party, allowing Woodbury to take a leadership role very early on in his public career, especially when the dominant party of the time, the Federalists, saw a decline in their power. As a New Hampshire Senate clerk, he befriended New Hampshire Governor William Plummer, and Plummer propelled Woodbury's career forward through a number of appointments, most notably to the bench of the state Superior Court. Upon his arrival in Washington, D.C., Woodbury aligned his support with Andrew Jackson, and when Jackson won the presidency, he appointed Levi Woodbury his Secretary of the Navy in 1828. He served in Jackson's cabinet throughout his presidency and into Martin Van Buren's presidency, where he served as the Secretary of Treasury. When William Henry Harrison took office, he returned to his position as a United States Senator. Levi Woodbury. Next person we're going to take a look at is Robert Cooper Grier. He was picked from Pennsylvania to replace Henry Baldwin. Robert Cooper Grier replaced Henry Baldwin, and he was the second of two appointees appointed by President James K. Polk. He served for 23 years and 174 days, from August the 10th, 1846, to January the 31st, 1870. And he did retire from the Supreme Court instead of dying in office. So let's look a little more in depth at Robert Cooper Grier. He was born March the 5th, 1794, in Cumberland County, Pennsylvania, and died September the 25th, 1870, in Philadelphia, Pennsylvania. While on the Supreme Court, he was also the Third Circuit Court judge. His education was, he got his Bachelor of Arts from Dickinson College in 1812 and law in 1817. And before becoming a Supreme Court justice, he was a private practice lawyer in Bloomsburg, Pennsylvania, 1817 to 1818. He was a private practice lawyer in Danville, Pennsylvania, 1818 to 1833. He was president judge of the District Court of Allegheny County, Pennsylvania, from 1833 to 1846, before finally being assigned to the Supreme Court. Let's see. He was educated at home. This is according to Britannica.com. He was educated at home, took over his father's educational academy in Northumberland, Pennsylvania, at the age of 21 and taught Latin, Greek, mathematics, astronomy, and chemistry at the same time that he was studying law. Despite his early association with the Democrats, Greer was a staunch Unionist during the Civil War. Although he concurred in the pro-slavery Dred Scott decision of 1857, he spoke for the court in the 1863 prize cases, which upheld the power of the president to proclaim a blockade of Confederate ports and to seize neutral shipping. His parents were both members of the Presbyterian clergy in Pennsylvania. His father made a living through various means, including farming, preaching, and teaching at a grammar school. Greer was admitted to Dickinson College and entered as a junior in 1811, graduating the following year at the age of 18 years old. And this is from oyez.com, or oyez.org, my apologies. After his father passed away in 1815, who he had been studying law under, he then continued legal studies under Charles Hall. Greer had a spotless attendance record for the first 21 years of his tenure on the Supreme Court. But in 1867, he finally missed a session due to an illness that left him partially paralyzed. His ideology most closely aligned with Justice John Marshall, the Federalists. He was known to forge his own path when his opinion demanded it. So it looks like that's everything. Robert C. Greer. Let's look at the next person we want to talk about. He is Benjamin Robbins Curtis. He replaced Levi Woodbury and was appointed by Millard Fillmore, being Fillmore's only Supreme Court appointment. He was on the bench for 5 years and 355 days, from October the 10th, 1851 to September the 30th, 1857. And it says here it wasn't retiring or dying, it was resigning, it said. So let's see what we can find out about Benjamin Robbins Curtis. Oh, yeah, he was from Massachusetts. I forgot to mention that. But let's take a look at him. Benjamin Robbins Curtis. He was born November the 4th, 1809, in Watertown, Massachusetts. He died September the 15th, 1874, in Newport, Rhode Island. And when he was on the Supreme Court, he was also a member of the First Circuit Court as justice. His education is Harvard Law School, Harvard University, when he gets the degree in 1829. And before becoming a justice, he was a private practice lawyer in Northfield, Massachusetts, 1831 to 1834, a private practice lawyer in Boston, Massachusetts, 1834 to 1851, and then also he went back to Boston after he left the Supreme Court, become private practice lawyer again in Boston, 1857 to 1874. Let's take a more in-depth look at who Benjamin R. Curtis is. After studying Harvard Law School, he took over the practice of a country attorney in Northfield, Massachusetts. He quickly gained a reputation in Boston for his ability. He was an ardent Whig supporter, WHIG, one of the other political parties, and a supporter of Daniel Webster. He gave the opinion of the court in Cooley versus the Board of Port Wardens, which established the broad power of Congress to regulate interstate and foreign commerce. And in Murray's Lassay versus Hoboken Land and Improvement Company, which confirmed the government's power to assess and collect sums due to it by its agents without resort to law. And again, this is from Botanica.com I'm reading from. So his most famous opinion and his last on the Supreme Court was his dissent in the Dred Scott case. So he dissented from the court's opinion, which, if we remember from what we've heard already about Dred Scott, it said Dred Scott was not a citizen, being that he had been a slave. In the wake of an unpleasant public correspondence with Chief Justice Roger Taney, who had echoed the slavers' sentiments, Curtis resigned from the Supreme Court. So over the next 17 years, he argued more than 50 cases before the Supreme Court. And in 1868 was President Andrew Johnson's chief defense counsel in his impeachment trial. 5 years after he was born, this is from oyez.org, 5 years after Curtis was born, his father, who was a ship captain, died and left Curtis's mother to care for their 2 children. And to support her family, she started a dry goods business and and maintained a library. So Curtis was a bit of an avid learner, given that he was often surrounded by books, and was admitted to Harvard at the age of 15. He graduated with the highest honors in 1829 and then attended Harvard Law, which was then run by Supreme Court Justice Joseph Story, and graduated in 1832, being admitted to the bar after a short break in his education. While he was involved in many types of law, Curtis was most often known for patent law. His work as a patent lawyer. And again, this is from oyez.org. Curtis was chosen as Justice Levi Woodbury's replacement to create a balance between the Whig and Democratic parties in 1851 by President Fillmore. But Curtis only spent 6 years on the bench, but nonetheless made a lasting impact in his time. Curtis became particularly disenchanted with the court around 1855 and missed his family and home he left behind in Boston, and struggled to financially support himself and his family on his annual salary. Furthermore, he decided to consistently uphold the constitutionality of the Fugitive Slave Act of 1850, which was legislation that allowed runaway slaves to be captured and returned to their owners, and imposed hefty penalties on individuals who interfered with their capture, even though he found the act itself abhorrent. This made him very unpopular among the northern population. It made him unpopular among the northern population because remember, he upholds this Fugitive Slave Act of 1850 that slaves must be allowed to be captured and returned to their owners. and also imposes hefty penalties on those who interfere with capture. So what was the name of it? The railroad. I can't remember the name of the. I cannot remember the name of the stupid thing. It's something railroad. I'm sorry. My memory is just. But anyway, the court faced this issue again in 1857 in the case of Dred Scott versus Sanford, and this decision left a major blemish on the court's record, but it was particularly disastrous for Curtis, who dissented from the majority opinion. Curtis based his opinion on the premise that Roger B. Taney, the Chief Justice and author of the majority opinion, stated that black people were not and could not be citizens. However, Curtis pointed out 5 states had granted them citizenship and that living on free soil granted slaves freedom. His dissenting opinion was published without his knowledge in a Boston newspaper before the majority decision was published. Taney saw this as an affront to the court, and then this incited a feud between himself and Curtis. And this is where we get the correspondence between the two. Scathing letters were sent back and forth between the two until Curtis resigned in 1857. So yeah, that is everything on him. Benjamin Robbins Curtis. The next person we want to look at is John Archibald Campbell. He was picked from Alabama to replace Justice John McKinley, and was picked as the only Supreme Court nomination appointment by Franklin Pierce. He served 8 years and 19 days, from April the 11th, 1853 to April 30th, 1861, when he resigned. So he also resigned from the Supreme Court. Let's take a in-depth look at him, John Archibald Campbell. He was born June the 24th, 1811, in Washington, Georgia, and died March the 12th, 1889, in Baltimore, Maryland. On the Supreme Court, he also served as the justice for the Fifth Circuit Court. His education, according to fjc.gov, is Franklin College, now known as the University of Georgia, 1825, and Reading Law, 1829. Before being put on the Supreme Court, he had a private practice in Washington, Georgia in 1829, then a private practice in Montgomery, Alabama, 1829 to 1837, then a private practice in Mobile, Alabama, 1837 to 1853, was a state representative for Alabama, 1837, and then was also state representative for Alabama in 1843, was Assistant Secretary of War for the draft of the Confederate States of America, 1862 to 1865, and then finally was a private practice lawyer in New Orleans, Louisiana, 1865 to 1884. Let's see if we can dig a little further into John Archibald Campbell. At the age of 11, this is according to Britannica.com, at the age of 11, Campbell entered Franklin College, now the University of Georgia, and after graduating at the age of 14, entered the U.S. Military Academy. Called home upon the death of his father, Campbell then began to study law and was admitted to the bar at the age of 18 by a special act of the legislature. He then soon moved to Alabama, where he married. In addition to maintaining a large private practice, he also served 2 terms in the Alabama legislature. At the age of 41, he was appointed to the U.S. Supreme Court and was known as a strict constructionist, and his views on states' rights were decidedly Jeffersonian. His tenure was notable for his concurring opinion in the Dred Scott decision, which made slavery legal in all the territories and fanned the flames of sectional controversy which led to the American Civil War. Though he opposed the Southern states' secession from the Union, Campbell did resign from the Supreme Court in 1861 and cast his lot with the South. And in 1862, the Confederate President Jefferson Davis appointed him Assistant Secretary of War for the Confederacy, a position he would hold until the South was defeated. According to Oz.org, not only did he graduate as a 14-year-old from the University of Georgia in 1825, he even earned high honors. His father's sudden death in 1828 ended Campbell's unsuccessful stay at West Point. His father's estate was deep in debt, forcing Campbell to work as a teacher for a year in Florida. Once the debt was settled, Campbell returned to Georgia and began his education as a lawyer under the tutelage of his 2 uncles, John W. Campbell and John Clark. In the Supreme Court, while he was pro-slavery, he did express those opinions to the opposition in a respectful manner, which went a long way with the Northern abolitionists, who often agreed to pass Campbell's well-constructed compromises. Campbell never believed that seceding was the correct path, and even freed his own slaves before he took the Supreme Court bench to prove it. When such cases as Dred Scott versus Sanford came up, he wished to give a ruling as narrow as possible so as to avoid issues that perpetuated tensions between the North and South. When the Confederacy was first created in 1860, many officials from the North refused to validate the new state by meeting with its officials. Campbell tried to act as a mediator to no avail and resigned from the Supreme Court in 1861, moving back to Mobile, Alabama. Southerners viewed his attempts to mediate as a betrayal and threatened to lynch him, so he moved to New Orleans to set up his law practice there. Eventually, the Confederacy sought him out to work as Assistant Secretary of War, and Campbell accepted the position but was vocal for his desire for peace. In 1865, the President of the Confederacy, Jefferson Davis, granted Campbell permission to meet with President Abraham Lincoln and arrange the terms of the South's surrender. Shortly after they struck an agreement, Lincoln was assassinated, and Campbell found himself imprisoned. The North was so angered by the assassination that they accused Campbell of misrepresenting what Lincoln stated his views were toward surrender during the meeting. The charges, though, were dropped 4 months later through the efforts of his old colleagues Benjamin Curtis and Samuel Nelson. Even after his release, Campbell struggled financially because the Reconstruction Act limited opportunities for secessionists. Eventually, the Supreme Court decided in Ex parte Garland that an act barring attorneys from practicing in federal courts unless they swore an oath that they never aided the Confederacy was unconstitutional. That decision allowed Campbell to argue in front of the Supreme Court again, and did so for about 6 cases a year, his most famous being the slaughterhouse cases, which revolved around a monopoly in the slaughterhouse business granted by Louisiana statute. All right, but that seems to be everything. John Archibald Campbell. The last person we're going to look at today is Nathan Clifford, and he was picked out of the state of Maine. He replaced Benjamin Robbins Curtis, and was the only Supreme Court appointment by James Buchanan. He would serve 23 years and 185 days from January the 21st, 1858 to July the 25th, 1881, dying as a Supreme Court justice. So let's take a closer look at Nathan Clifford. He was born August the 18th, 1803 in Rumney, New Hampshire, and died July the 25th, 1881 in Cornish, Maine. While on the Supreme Court, he was also the First Circuit Court Justice. His education, according to fjc.gov, was that he read law in 1827. And before becoming a Supreme Court Justice, he was a private practice lawyer in Newfield, Maine, 1827 to 1830, a state representative for Maine, 1830 to 1834. He was also Speaker of the State House of Representatives for Maine, and then he was Attorney General for the state of Maine from 1834 to 1838. And then he was a United States Representative from Maine in 1839 to 1843, then going back to his private practice as a lawyer in Newfield, Maine, 1843 to 1846, and then becoming Attorney General of the United States, 1846 to 1848, then becoming Minister to Mexico in the U.S. Department of State, 1848 to 1849, and finally being a private practice lawyer in Portland, Maine, 1849 to 1857, before finally being added to the United States Supreme Court. So let's see if we can take a closer look on who Nathan Clifford was. Okay, according to oyez.org, Nathan Clifford delivered over 400 opinions as a Supreme Court justice, although he only wrote on issues related to commercial and maritime law. He was the only son of 7 children and raised in the small town of Rumney, New Hampshire. He began studying law at the age of 18, working at the law office of Josiah Quincy, and 5 years later was admitted to practice and moved to the farmlands of Newfield, Maine, where he was the only lawyer in town. It was here that he would meet Hannah Iyer and get married within the first year of living at Newfield. He was appointed U.S. Attorney General by James K. Polk and served for 2 years, and then appointed by Polk as the United States representative for the purposes of establishing a peace treaty between the United States and Mexico following the war, the U.S.-Mexican War. So Clifford would remain in Mexico until the end of the Polk administration in 1849. Nathan Clifford held his seat as a Supreme Court justice for 23 years without addressing a constitutional issue. However, Clifford is well known for his supporting role in Hepburn versus Griswold, which declared certain parts of the Legal Tender Act unconstitutional. The Legal Tender Act was passed during the Civil War for the purposes of funding the economy with U.S. notes. However, the act was overruled because the U.S. notes were deemed a depreciated medium of exchange that ultimately denied creditors due process of law. In 1877, Clifford chaired the Electoral Commission for the presidential election. Although he remained true to his political domain and supported the Democratic aspirant, the commission ultimately voted in favor of Republican Rutherford B. Hayes. So yeah, Nathan Clifford. But that will be everything. I will have I can't think of the word. Sources. My mind just goes on me sometimes. I can't think. See, Underground Railroad. See, I can think of the Underground Railroad now, even though I was trying to say it earlier. But I will have the sources in the description below the video. As always, educate thyself. Think, read, study, learn. Someone tries to say something you have trouble believing, ask them to cite their sources. I'll see you all in the next one. Until then, later.